If you became a US citizen through naturalization, and lately you've been losing sleep wondering whether it can be taken away, you're not alone. The headlines are everywhere. Enforcement operations, deportation stories, immigration crackdowns. And suddenly, what once felt permanent starts feeling uncertain. You studied for that civics test. You stood in that courtroom. You took the oath. You believed that moment meant security. So when immigration dominates the news in February 2026, it's completely natural to ask, has anything changed about my citizenship? Is it really secure? Could these enforcement policies somehow affect me? Today, we're separating fear from fact, headlines from law, and anxiety from constitutional reality. Because there's a huge difference between aggressive enforcement and an actual legal threat to your citizenship. Understanding that difference changes everything. Hi, I'm Sophia, and welcome to US Updates. I focus on breaking down immigration policy clearly and factually, especially when fear spreads faster than accurate information. In this video, we're walking through what current immigration policy actually means for naturalized citizens, what the Constitution guarantees, what denaturalization really involves, and what practical steps you should take right now. This isn't about politics. It's about law, rights, and clarity. By the end, you'll know exactly where you stand and what you can stop worrying about. Let's start with the foundation, because understanding this clearly makes a lot of the fear disappear. Under the United States Constitution, citizenship, once lawfully granted, is permanent. That's not a talking point. That's not dependent on who sits in the White House. That's constitutional law backed by Supreme Court precedent going back decades. If you completed naturalization, met residency requirements, passed your exams, disclosed required information, and took the oath of allegiance, you are a United States citizen with identical constitutional protections as someone born here. Your citizenship is not a visa, it's not a green card, it's not conditional, it doesn't renew, it doesn't expire, and it cannot be taken away simply because enforcement becomes more aggressive or political leadership changes. Executive orders cannot override constitutional protections. Enforcement strategies cannot rewrite the 14th Amendment. Congress cannot pass a simple law stripping lawfully naturalized citizens of their status. Citizenship, once properly granted, is one of the strongest legal statuses in American law. Let me pause here because this is crucial. Many people unconsciously carry the anxiety they felt as permanent residents into their life as citizens. As a green card holder, your status could be questioned. There were conditions, risks, renewal requirements, travel limitations. Citizenship is fundamentally different. It's final. It's constitutional, not administrative. And if this clear breakdown helps you, subscribe to this channel so you don't have to rely on rumors next time immigration headlines explode. Accurate information is powerful protection. But there is one narrow legal exception people hear about without fully understanding it. It's called denaturalization. This word causes panic because it sounds like the government can simply undo citizenship. That's not what it means. Denaturalization is a formal legal process that only happens in federal court and only under very specific circumstances. The government must prove that someone obtained citizenship through fraud or by willfully concealing a material fact during naturalization. This isn't about policy disagreements. It's not about political views. It's not about criticizing the government. It's about whether the original naturalization was legally valid. To meet that standard, prosecutors must show evidence that someone deliberately lied on their application, hid serious criminal history that would have disqualified them, used a false identity, concealed involvement in persecution or terrorism, or omitted legally material information. And even then, it's not automatic. The government must file a civil lawsuit. The individual has the right to representation. There's discovery, evidentiary standards, a judge. The burden of proof is high. Historically, denaturalization cases are rare, time-consuming, and expensive. They're not mass administrative actions. They're individualized court proceedings that often take years. This distinction matters enormously in 2026, because when people hear about stronger enforcement, some assume citizenship could be swept into that wave. But denaturalization isn't a policy tool that can be casually expanded. The legal standard hasn't changed. There's been no new law lowering the burden of proof. There's been no Supreme Court ruling weakening constitutional protections. Even if an administration wanted to pursue denaturalization more aggressively in proven fraud cases, it would still be bound by the same constitutional requirements that have existed for decades. So when you hear the phrase revoking citizenship, understand it refers to a narrow, court-driven process tied to fraud, not a political lever that can be pulled against law-abiding naturalized Americans. If naturalized citizenship is constitutionally protected and denaturalization is rare and fraud-based, what's happening right now in February 2026 that's making people uneasy? The answer is enforcement visibility. The current administration has significantly increased immigration enforcement operations. ICE activity is more frequent and more public. Detention policies are stricter. Border enforcement has intensified. Deportation efforts are prioritized for individuals who are undocumented or have final removal orders. That shift in visibility changes how communities feel, even if it doesn't change the legal reality for citizens. When you see workplace raids on the news, when you hear about large-scale removal operations, when social media amplifies every enforcement story, it creates the impression that the entire immigration landscape is unstable. But here's the critical distinction. Enforcement actions target immigration status violations. Naturalized citizens don't have an immigration status. You have citizenship. You're not in the category of people subject to deportation proceedings. You don't need a visa. You don't need to renew anything. Your legal relationship with the United States is fundamentally different from someone who's undocumented or even a permanent resident. This is where confusion spreads. Immigration policy debates get framed broadly. Crackdown on immigrants, strict immigration overhaul, new deportation push. But those phrases collapse multiple legal categories into one emotional headline. A green card holder isn't the same as an undocumented immigrant. A visa holder isn't the same as a naturalized citizen. Enforcement aimed at unlawful presence doesn't legally extend to people who've completed naturalization. Yet when rhetoric becomes intense, people who spent years in a vulnerable immigration system can instinctively feel like that vulnerability has returned. It hasn't. The tone may be harsher, enforcement may be more visible, but tone isn't law. Visibility isn't a constitutional amendment. And intensity doesn't rewrite citizenship protections. Let's address 3 common claims circulating right now, because misinformation thrives in environments like this. The first claim is that mass denaturalization is coming, that the government is preparing to strip citizenship from large numbers of naturalized Americans. There is no legal mechanism for this. There's no new legislation authorizing it. There's been no constitutional change allowing it. Denaturalization requires individualized federal court proceedings tied to fraud. It cannot be executed in bulk through administrative action. The second claim is that certain nationalities or religious groups are being targeted for citizenship revocation. While enforcement priorities can focus on particular regions or security concerns, denaturalization cases must be based on fraud or material misrepresentation, not race, religion, ethnicity, or political belief. Targeting citizenship revocation based on those characteristics would be unconstitutional and immediately challenged in federal court. The third claim is that naturalized citizens need to take urgent, dramatic steps to protect their citizenship. Renouncing prior citizenship immediately, filing special paperwork, paying for protection services. None of that is necessary. Your citizenship is protected by the Constitution, not by additional filings or private services. Fear-based businesses often emerge during uncertainty. Be cautious of anyone asking you to pay money to secure something that's already legally secure. Understanding what's actually happening versus what's not changes how you respond. There is a real enforcement shift in 2026. There's heightened focus on undocumented status. There's political intensity around immigration. But none of those developments alter the constitutional permanence of lawfully obtained naturalized citizenship. When you separate enforcement optics from legal authority, the picture becomes much clearer and much less frightening. Now let's shift to something practical. Not because your citizenship is in danger, but because clarity becomes more powerful when you know what to do next. First step, safeguard your documentation. Keep your naturalization certificate in a secure location. Make physical copies and secure digital scans stored safely. This isn't because someone's coming to question your citizenship randomly. It's because having immediate access to proof eliminates stress if you need to apply for a passport, replace documents, sponsor a family member, or verify your status. Organization reduces anxiety. Second step, understand your rights as a citizen. You have full constitutional protections. You have the right to due process. You cannot be deported. You can travel on a U.S. passport. You can vote. You can petition for family members. These rights aren't symbolic, they're enforceable. Sometimes simply reviewing what citizenship legally grants you restores stability that headlines temporarily shake. Third, if you have family members who are lawful permanent residents and eligible for naturalization, this is an important moment to encourage them to apply. Permanent residence is strong, but it's not the same as citizenship. Green card holders can still be placed into removal proceedings under certain circumstances. They must maintain residency requirements. They're subject to immigration enforcement rules in ways citizens are not. Naturalization provides finality. The process itself hasn't fundamentally changed in 2026. It still requires physical presence, continuous residence, English proficiency, civics knowledge, and good moral character. But if someone in your family qualifies, pursuing citizenship provides long-term security that's particularly meaningful in an enforcement-heavy climate. If this breakdown is helping you think more clearly, consider sharing this video with someone who might be quietly worried but hasn't asked these questions out loud. Sometimes clarity spreads one conversation at a time. Now let's talk about more complicated family scenarios, because this is where anxiety really lives. If you have undocumented relatives, the current environment isn't favorable for ignoring that reality. Enforcement is active. Deportations are occurring. Undocumented status carries real vulnerability. Hoping visibility will fade isn't a strategy. That doesn't mean panic. It means consultation. There may be pathways someone hasn't explored. Adjustment through family, humanitarian protections, waivers, cancellation of removal, or other relief depending on the facts. But those options are case-specific and require a licensed immigration attorney to evaluate properly. Guesswork and internet advice are dangerous in this climate. If you're sponsoring a relative abroad, understand that family-based immigration remains legal, but processing times may lengthen, scrutiny may increase, and policy adjustments could affect categories or numerical caps. Delaying unnecessarily can sometimes mean facing stricter standards later. And if you travel internationally as a naturalized citizen, always travel on your U.S. passport. The United States recognizes dual citizenship, but some countries don't. If you return to your country of origin, be aware of that country's laws regarding dual nationality, taxation, or military obligations. None of those issues affect your U.S. citizenship, but they're practical realities worth understanding before you travel. What all of this comes down to is this: your citizenship itself is stable, but your family's immigration situations may still require attention. Stability at the top doesn't automatically secure every level beneath it. Being proactive, not fearful but proactive, is the most constructive response to a high enforcement environment. At this point, you might be asking, do I need an immigration attorney right now? For most naturalized citizens with straightforward histories, the answer is no. If you obtain citizenship lawfully, disclosed required information honestly, and haven't been contacted by the government regarding fraud or misrepresentation, there's no preventive legal filing you need to make. There's no special protective step required. Citizenship doesn't need maintenance. It doesn't need renewal. It doesn't require defensive paperwork. However, there are specific situations where consulting an immigration attorney makes sense. If you're sponsoring a family member and the case involves prior overstays, removal orders, criminal history, or complex waivers, you absolutely want professional guidance. If you have undocumented relatives trying to assess their options, that evaluation must be individualized. If you ever receive formal communication from USCIS, the Department of Justice, or any federal agency questioning past immigration representations, that's the moment to seek counsel immediately. And when I say attorney, I mean a licensed immigration lawyer, someone admitted to practice law, ideally focused specifically on immigration matters, and preferably connected to reputable organizations like the American Immigration Lawyers Association. Be cautious of anyone who guarantees outcomes. Be cautious of large cash demands without written agreements. Be cautious of notarios or consultants presenting themselves as attorneys when they're not licensed to practice law. Immigration fraud increases during uncertainty because fear creates opportunity. A real attorney will evaluate your facts, explain risks clearly, and never promise impossible results. They won't tell you they can protect already secure citizenship for a fee. They won't invent emergency filings that don't exist. Legal guidance should reduce anxiety, not exploit it. Now, I want to shift to something that doesn't show up in statutes or court rulings, but is very real: emotional residue. Many naturalized citizens carry years, sometimes decades, of immigration-related stress. You may remember what it felt like to wait for visa approvals, to check case statuses obsessively, to worry about missing a document, to fear that a mistake could derail everything. That psychological imprint doesn't disappear overnight just because you received a naturalization certificate. So when enforcement headlines surge, even if your logical brain understands your citizenship is secure, your nervous system may react differently. You might feel a flash of the old vulnerability. You might question something that's legally settled. That reaction doesn't mean you misunderstand the law. It means you lived through uncertainty for a long time. It's important to give yourself credit for that journey. You navigated a complex legal system. You met the requirements. You earned citizenship lawfully. The anxiety you once felt was rational in earlier stages of your immigration process, but the legal landscape of your status has changed. You're no longer in a provisional category. If the current political climate reactivates old fears despite knowing the legal facts, consider leaning into community. Talk to other naturalized citizens who share similar experiences. Connect with immigrant advocacy organizations that provide accurate updates. If stress feels overwhelming, there's no weakness in seeking counseling support to process it. Security isn't only a legal condition, it's also a psychological one, and both matter. As we look at the bigger picture in February 2026, it's important to separate two forces that often get blended together: political climate and constitutional structure. Political climate can shift quickly. Enforcement priorities can intensify. Public rhetoric can become sharper. Media coverage can amplify every action. But constitutional structure moves slowly, deliberately, and with high barriers to change. Citizenship falls into that structural category. It's anchored in the 14th Amendment and reinforced by decades of Supreme Court precedent. That foundation doesn't move with each election cycle. So when you hear sweeping language about immigration crackdowns, remember that those policies operate within legal categories: undocumented status, visa violations, removal orders, asylum eligibility. Citizenship is a different category entirely. If you naturalized lawfully and honestly, there's no hidden mechanism waiting to undo that. There's no executive shortcut. There's no quiet administrative sweep. There's no new 2026 statute that has rewritten the rules of denaturalization. The legal standard remains fraud or willful concealment of material fact proven in federal court with full due process protections. Here's what we know clearly. Immigration enforcement in 2026 is visible and active. Deportations of undocumented individuals are occurring. Border and detention policies have tightened. Policy debates around asylum, work visas, and family-based immigration continue. But none of those developments alter the permanence of lawfully obtained naturalized citizenship. If you answered your application truthfully, disclosed what you were required to disclose, met eligibility requirements, and took the oath, your citizenship is secure under the Constitution. That's not optimism, it's legal fact. So the path forward isn't panic, it's awareness. Stay informed through reliable sources like USCIS, the State Department, reputable legal organizations, and licensed immigration attorneys. Keep your documents organized. Encourage eligible family members to naturalize. Seek professional advice when cases are complex. And most importantly, allow yourself to live in the stability you earned. You have the right to vote. You have the right to hold a U.S. passport. You have the right to petition for family members. You have the right to live here without fear of deportation. Those rights aren't symbolic. They're enforceable constitutional protections. And understanding them fully is one of the strongest responses to a noisy political environment. If this video has helped you feel clearer about what naturalized citizenship actually protects and what it doesn't, make sure you subscribe to US Updates. We're committed to fact-based immigration guidance that cuts through misinformation and focuses on what the law actually says. Share this video with someone who might be worried but hasn't had access to accurate information. And if there's a specific claim you've heard or a topic you want us to address next, leave it in the comments. Your questions help shape future videos that serve real concerns in our community. Thank you for being here, and thank you for being part of a space where accurate information is treated as protection, not politics.